Thank you, Chairman Gill, Ranking Member Simon, members of the committee for this opportunity to testify before you today. The American Bar Association has abandoned its mission to provide best practices for the legal profession. Instead, it has opted to push a partisan program full of radical policies. For example, the ABA has weighed in on hot-button cultural issues by supporting nationwide abortion and racial discrimination at American universities. It has opposed Second Amendment rights and has attacked states that refuse to let children cut off their genitals if they feel they were born in the wrong body. Even more egregiously, for an organization supposedly dedicated to the rule of law, it has taken the absurd and patently incorrect position that our Constitution has 28 instead of 27 amendments. This position that the Equal Rights Amendment has become part of our Constitution is so egregious that even the Biden-appointed Archivist of the United States, the official that certifies newly enacted constitutional amendments, rejected it out of hand. As a private organization, the ABA is free to adopt almost any policy it wishes, but the federal government recognizes the ABA's Council of the Section of Legal Education and Admissions to the Bar as the sole federally recognized law school accreditor. And when this entity, which is nominally under the auspices of the ABA, exercises government-sanctioned authority, it must comport with the Constitution. But it doesn't. In fact, as current President Michelle Benke made clear in a February 2026 speech, the ABA will not abandon its commitment to diversity, equity, and inclusion because now is not the time to take back the progress that we have made. And she delivered introductory remarks at the ABA's 2026 Equity Summit, which the ABA Diversity, Equity, and Inclusion Center hosted in coordination with the ABA's DEI Advisory Council. The summit included panels with titles like Disparate Impact Liability and Old Innovation That Remains Advantageous, Beyond Rainbow Logos centering LGBTQ+ voices who fuel innovation, equity, and better lawyering, and professional conduct in a fractured climate, Model Rule 8.4G, DEI challenges, and ethical lawyering. Now, for those unfamiliar with the ABA's Model Rule 8.4G, it's a chilling speech code put forward by the ABA under the guise of policing the professionalism of lawyers. But it has drawn condemnation from across the political spectrum. And one Pennsylvania federal court found that Pennsylvania's version of this professional conduct rule, which was based on the ABA's model, was unconstitutional, though that case was later dismissed for other reasons. While the Council is supposed to be nominally independent from the larger ABA, there are very real reasons to question just how independent the Council really is, given the co-branding and Byzantine relationship between the two entities. Even setting aside that overlap, the Council itself has taken a number of controversial actions, including targeting law schools such as George Mason or St. Thomas for not implementing its radical DEI and other progressive policies aggressively enough. Now that it's facing an existential crisis and the loss of its monopoly on law school accreditation, the Council seeks to back away from some of its most egregious positions. Consider, as we heard, that it now seeks to repeal Accreditation Standard 206, which requires law schools to demonstrate by concrete action a commitment to diversity and inclusion, which it interpreted as requiring law schools to treat students, faculty, and staff differently based on their race. But the Council isn't making this move having reevaluated its position or even after having reevaluated the proper role of an accreditor. It's making this move out of crass self-preservation. When it perceived the political winds to be blowing in a different direction several years ago, the Council demanded that law schools comply with Standard 206 even if constitutional or statutory provisions required otherwise. In other words, the Council said its rules trump the Constitution. That's shocking. So what's to be done? First, Congress and the executive branch should build on the good work that has been done and eliminate the ABA as the sole law school accreditor. Congress should update relevant statutory provisions to prohibit the recognition of any accreditor that imposes DEI requirements, and Congress should build on the work of states that have eliminated the ABA as the gatekeeper to state bar exams. If other states continue to rely solely on the ABA for this function, Congress should strip those states of relevant federal funds. As Justice John Marshall Harlan had the foresight and fortitude to make clear 130 years ago, our Constitution is colorblind and neither knows nor tolerates classes among citizens. But the ABA has been using its accrediting authority to undermine these constitutional commitments to equal treatment regardless of race. In closing, the federal government and states must continue to take actions to end the ABA's monopolistic status as a law school accreditor.